I want us to focus on matters that pertain to land, given that when you look at land, it's more than an economic asset. It represents culture, intergenerational wealth, dignity, and even in some cases, political power. However, when it comes to land disputes, it's not simply about who is holding the title deed. But also, should legal ownership override, say, a community's attachment to land from which they were displaced? That is why we are asking, can statutory ownership coexist with ancestral claims when it comes to matters of land? That is the basis of our conversation today, of which I am having with Turunga Ithadi, who is an advocate and mediator. Karibu sana to Good Morning Kenya.
Thank you very much, Mike.
Karibu sana.
My name is Turunga Ithadi, as you mentioned.
Yes.
I'm glad to be here.
Karibu sana. And also Rebecca Wanjiku, who is has been a land claimant. Karibu sana.
Naitwa Rebecca Wanjiku.
Yes.
Ni mkazi wa Kakuzi.
Kakuzi.
Yeah.
Asante sana kwa kuja hapa KBC.
Asante.
And also Kimathi Kithure, who is a human rights defender. Karibu sana.
Thanks for having me.
You're doing great this morning.
Yes, thank you.
Let's get into the conversation, and I want to start with you, Wakili. You know, when it comes to matters land and the Constitution, it does protect the right to property under Article 40. And on the other hand, Article 67 empowers the National Land Commission to investigate historical land injustices. Now, when you look at the Constitution, how should we reconcile as a country? How can we reconcile the protection of registered property with the rights, the need to remedy historical land injustices without weakening other principles?
Thank you, Mike. So, under Article 67 of the Constitution,
yes,
the National Land Commission is established, and it's operationalized by the National Land Commission Act and the Land Registration Act 2012. Yeah? And the mandate of the Commission basically is to manage public land. It also has the mandate to investigate and give restitution for both current and historical injustices. And now the gist of it is that there's no time limitation whatsoever. Parliament had tried to cap this at 5 years.
Yes.
But now with the human rights issue or the historical land injustices issue, there's no time limit. So you can bring a claim under historical land injustice from way back. For example, now like my co-panelist
yes,
from Kakuzi, recently they got a ruling in Murang'a whereby the High Court in Murang'a declined to grant them leave to file a substantive judicial review, and also declined to grant them a stay of execution. Basically, they were seeking a stay of execution against the rulings that came up in 4 claims that had been filed with the National Land Commission, whereby the National Land Commission ordered, among other things, that Kakuzi should cede 3,200 acres to the locals. This is a paltry, maybe quarter of the entire estate that they own. This is not the first time that they've been in trouble. In 2019, they were sued again by about 85 locals for killings and sexual violence. Their parent company in the UK, called Canalia PLC, managed to settle this at around 696 million. So, as it is, the reason they were seeking stay, and perhaps the reason they wanted the decision of the Commission quashed, is because it may open a Pandora's box for class action claims that may come, and basically they are very expensive. There are many groups of people that may come claiming, and as such, that is why they are seeking to find a way to block all this. However, the High Court asserted that the mandate of the National Land Commission and Article 67(2) was properly exercised by the Commission, even in not giving these orders, ordering restitution, And also there was another order that 50 acres will be ceded to the county government of Murang'a, where in exchange for 5 acres, which I think have already been identified. This is for purposes of public utilities and all that, and planning, and even schools and all that. So as it is, there's criticism on the commission since it was established that it hasn't done much, but we are starting to see that reparations will be done. Yes.
Rebecca, you've been involved in these matters. Umekuwa kwa haya maneno ya inahusiana na ardhi. Ukiangalia venye haya maneno yanaenda, unajua watu wengi wanga wamehusika katika haya maneno ya ardhi. Ukiangalia kupata haki kulingana na wewe inafanana aje? Ndio useme tumekuwa na haya maneno ya ardhi na tulikuwa tunataka haki, sasa tumeipata. Haki inakaa aje kulingana na wewe?
Sasa sisi tumepigania hii shamba yetu wakati mrefu, kama miaka 10 imeisha, na inaonekana nini vile na kutoka wazazi wetu wanyang'anywe hii shamba. Kama baba yangu alikuwa supervisor huko Kakuzi, akakufa, akaacha mama yangu. Alipoacha mama yangu na watoto, Kakuzi wakakuja wakafukuza mama yangu. Walimtupanisha kama kitu mbaya. Walikuja wakamuita tu kama ni wanampeleka mahali pazuri. Wakamwambia, Nyambura, ebu toa watoto wako na vyombo zako tukupeleke mahali pazuri pa kukaa. Lakini wakatupanisha mama yangu mahali, walimtupanisha mpaka mama yangu akashikwa na depression. Kwa hivyo kutoka wakati huo mama yangu, watoto wake hawakusoma tena. Tukanyang'anywa huko. Tulikuwa na shamba mingi sana mpaka mahali kunaitwa Jericho huko Kakuzi. Tulikuwa na mashamba zetu mingi, lakini Kakuzi kuonyesha wanakupenda, lakini kumbe wanataka watunyang'anye mashamba zetu. Walichukua watu wengi wakawatupanisha. Mama yetu akatupanishwa hivi hivi. Wengine wakapelekwa milimani. Sasa mama yangu vile alishikwa na depression, angeweza kwenda mahali. Mama yangu akakaa kama ameshikwa na wazimu. Kwa hivyo mama yangu maisha yake ikaisha hapo hapo mpaka mama yangu akakufa. Kwa hivyo sisi tumekaa na shida ya hii mashamba. Tumekaa na shida sana, sababu hata njia, barabara zote wametunyima mpaka barabara za kwenda huko milimani.
Ndio sasa tukuje kuona kulingana na wewe ndio haki itendeke. Haki na kulingana na wewe, haki, justice kwa hii maneno yote ya land, kulingana na wewe inafaa kukua vipi?
Ndio haki itendeke, ni serikali tu wakubali waturudishie shamba zetu, ndio haki itendeke. Hata Mungu akiwa mbinguni aone kweli wamefanya haki. Serikali wakubali tu watupatie title D, sababu tulishinda kesi na tuliwekwa kwa Kenya gazeti. Kwa hivyo watupatie tu shamba zetu, ndio haki itendeke, na sisi tusikie kweli tuko Kenya yetu na tunafurahia Kenya yetu, na mpaka wazee wetu, sababu kuna wazee kabisa hawana mali, hata wao wasikie wako Kenya yao. Kwa hivyo watupatie tu na wakubali watupe title deeds. Yeah.
Kimathi, when you look at matters of land and human rights standards on it, in a way it has linked culture, housing, food, security and identity on it. As a country, how are we going to incorporate these principles in land governance while respecting the right to private property?
So if we apply the human right-based approach to that issue, then one of the things is that we have to shift from looking at it as just a negotiable commodity or property, and look at it as a means in which a community is able to enjoy their dignity and other fundamental rights, including the right to practice their culture. Now, if you look at that, then that means you have to apply the human rights-based approach to the whole issue in where such issues are involved. And one of the things that we must note is that what is happening in this case is not unique. It happens many times within our country and outside our country as well. In Kenya, we have got other communities that could be categorized as indigenous peoples or minorities.
Yes.
They could include people like Ogiek, the Maasai, the Songwer, depending on how the extent to which they are marginalized and their way of life differs from the rest of the community. And therefore, when such issues are being dealt with, we have to look at the compliance with the international obligations as a country that we have to abide by. And here we'll be looking at, for example, the UN Declaration on the rights of indigenous peoples. We're looking at the African Charter on Human and People's Rights, and we also look at the ILO Convention number 169. Now, if you put in consideration of this framework, then you have to look at certain things when you're discussing it. Things like the procedural issues, like were the people given, did they have free, informed, prior consent? Was there adequate compensation? Was there public participation? And in cases where that has been violated, usually there has to be consequences, and we've seen that happen. For example, we've had issues like Endorois, where the government of Kenya was found to be in violation because they evicted the Endorois community from their land for game reserve. And that means they violated their right to ancestral land in that case, and of course the country was found to be in violation of that obligation. It has happened in other countries as well. For example, in Nicaragua, where the Inter-American Court also argued that where it is an ancestral land, it carries the same weight as where you have got a statutory title. Yeah, so those are things that have to be considered. So they are not new, but usually they have to be considered from a human rights-based approach, not just as a negotiable commodity.
Very important. And Ithadi, Kenyan courts have increasingly emphasized that having a title deed does not automatically settle every dispute. In some cases, sometimes the courts have examined the root of title, how that title was acquired, and in essence, the ownership of that land. My question to you is, should every title deed remain open to historical scrutiny, or certainly should legal certainty prevail?
For me, and certainly, I believe every title should remain open to scrutiny. Yeah, basically, holding that document, you can even have acquired it fraudulently, and that is why it can it can definitely even be cancelled because of having acquired, if you're able to prove that it's been acquired fraudulently. In this instance, we're talking about historical injustices. Where the people are saying that they were forcefully evicted, they were displaced, their houses were burnt, and all sorts of atrocities happened when this land was being acquired. That was back, I believe, in 1902. And then the leases that were issued were for around 941 years. Some astronomical figures that do not really make sense. The Constitution of Kenya 2010 came in and capped the leases at around 99 years for foreigners. So why would we say that this title should not be scrutinized? They definitely need to be scrutinized. And I need also emphasize on the need and the role that the court has played as well in doing away with the capping of the years. For example, in other cases, for example, in pension claims, you cannot bring an action maybe 3 to 10 years after the fact. That is the limitation of actions or the time statute. However, if you bring it and you're able to package it as a human rights issue, like what some people are doing in Tanzania, happened to be the lawyer for a group called Payroll 301, former East African workers from Tanzania who've never received their pensions to date. They are going after the colonialists, that is the crown agents, with whom they saved their pensions. But up to date, payment has not been done. However, having been able to package it as a human rights issue because they are suffering since 1977 to date, we were able to have Crown agents go into liquidation. Now we are dealing with a liquidator who's admitted our claims. And we hope that restitution will happen even in future. So I believe this title should be scrutinized.
And also, when you look at matters of land, you know, some of these injustices occurred decades before even the modern land registry was brought about. So communities often rely on oral history, while the owners now rely on documents. From where you stand, how can communities fairly prove that ancestral land, it's theirs, they occupied it, when formal records are limited?
Well, way before there were no records, it was all community land. So if a certain community is known to have been living somewhere, however you acquired it, because these leases were being given, they were being issued, and they were being issued for various reasons. We are not negating the fact that these people have also helped us. They've created employment, there are industries that can be built, but we also need to work as our own. This is our land, we are the people of the soil. Let's have a system or a structure where everyone benefits, right? Yeah, we come up with our own industries, whatever we're given, we utilize it well. One of the other orders that was issued by the National Land Commission is that the Ministry of Lands and the Ministry of Interior should vet these claimants and know who are the vulnerable people. These, of course, may open another Pandora's box because we know our country. However, we believe that the vulnerable people, the owners of the land, the communities that are there, should get their rightful share of their ancestral land. Yes.
Rebecca, katika hizi pilka za kupigania haki yenu katika maneno ya ardhi, ni nini unaweza sema imewasaidia sana katika harakati zenu za kupigania haki yenu?
Tumesaidika sana sababu ya mawakili wetu wamepambana mpaka tukaona sasa tumepata hiyo shamba. Na tukawa sasa tunaona na tunajua kweli tutarudishiwa mashamba zetu. Kwa hivyo mawakili wetu tunaweza washukuru sana, wamefanya kazi kubwa sana, na tena serikali nayo imefanya vizuri sana kwa kusema tupewe shamba yetu, sababu hata wao wamechangia. Na tunataka sasa ndio tuishike hivi, watuletee title D, ndio tuone sasa kweli ni kuingia tu kwa shamba yetu.
Kimathi, you know, some of these issues regarding land, mostly they pit two groups with legitimate interest on the land. But on one hand, there's a displaced community seeking justice, and the current owners who may have acquired that land lawfully. So my question to you is, how do we avoid resolving one injustice by creating another?
That can be done. Of course, the issues cannot be rushed, and that's why the due process has to be followed.
Yes.
And you also asked a question about how we can be able to recognize the customary rights, you know, in the context of laws whereby someone who is also holding a title, you know, that is issued from the government. And in a good country, we have to be able to accommodate the different things that are around us. And I'll give an example. One of these is usually the issues to do with the Marriages Act. You know, it recognizes, for example, that you can have, you know, a marriage, you know, in the customary sense, you know, you could be also belong to the different religion and all that, Christian, Islamic and all that. So what the law did is to acknowledge that we live in a context where all these have to coexist. But then there has to be a way in which they coexist in harmony.
Yes.
And therefore what needs to be done is that our laws usually recognize that. You know, the Constitution does not contradict, it recognizes such things whereby, so when handling those issues, then they have to look at they have to recognize the indigenous people as part of the owners. And that has to be respected by even the business enterprises when they go to an area. So, and those are the issues that also have to be considered by the courts of law when they have to decide on a matter. So they don't just look at who has got the paper, but they also have to look at the context as well.
And Ithadi, what principles should guide the balancing of these competing rights?
Well, the principles that should be there should be fairness and equitable ownership of land, first and foremost. No right should override the other,
yes,
definitely. But human rights, as we said, are fundamental and core in nature. And they are rights that are not derogable as well. You cannot simply deny the community their land because you are an investor. So due process ought also to have been followed. And then the fact that the lease period is actually quite astronomical also negates the fact that due procedure was followed. Because if it was followed, we should have gotten leases of up to 99 years renewable. That is, if it's upon expiry, you can reapply for renewal. But now getting to a point where the communities are being affected so gravely that they have no, they're saying they have no hope, basically. Up to now, they have no titles. All their cries for them to have their titles now and to own the ownership in their motherland. Yes.
And when you look at matters of land disputes, sometimes even those who own these lands did not participate in the injustices that that sometimes are talked about. So my question to you is, when you look at the current landowner, should they surrender their property in a manner, and they had no involvement in the original historical injustice? Should they surrender their property for historical injustices, or should the state provide remedies?
Irregular is irregular. If you acquire something irregularly, whether it was you or through proxy or through your father, your ancestors, it was irregular. Yeah. So if we are going to involve the government, let the government harmonize together with these stakeholders so that they know what is being ceded and or what they can pay these people to move away and resettle the locals.
Yeah.
Yeah.
And, Rebecca, ukiangalia hiyo process yote na hiyo wakati imechukua, unaweza sema imeathiri aje wale watu mlikuwa pamoja na wao mnapigania nao, ikikuja ni mambo ya kiuchumi, ikikuja ni mambo ya kutafuta mahali kwa kukaa, hiyo kungojea haki itendeke imewaathiri kivipi?
Imetuathiri sana, kwa sababu kama saa hii hata chairman wetu asikii vizuri, sababu hata ako na stress, anasemanga anataka tu aone tumeingia kwa mashamba zetu. Tena imetuathiri sana. Watoto wetu wanazungukanga wakienda mbali sana, wakienda mpaka shule. Inatuathiri sababu hatuna hata mahospitali huko. Hatuna hata mashule ziko mbali na wale wamefunga njia kila mahali. Kwa hivyo hakuna mtu anaweza pitia. Hata wale wanatoka huko wakienda kazi mahali fulani wanapita njia kubwa, njia refu sana. Kwa hivyo imetuathiri kabisa. Tumeathirika kinini sana.
Kabisa. And Kimathi, you know, courts can resolve legal disputes regarding matters of land, but sometimes they do not always heal historical injustices or grievances, or even rebuild trust within communities. Should we rely more on mediation? And I'll ask the same question to you, but I want to hear from him first. Should we rely more on mediation, truth-telling, and community reconciliation processes rather than litigation?
Yes, I agree, Mike. So there has to be, we have to apply the alternative dispute resolution mechanisms in this case, just to ensure that there's a solution that is able to factor in all the needs of both sides, and in an amicable way. So, and therefore, mediation and other ways, they have to be employed. So I think that also helps, so that ultimately, whatever the decision is arrived at, both sides, as you said, there's always contention between both sides.
Yeah.
They have to coexist at the end of the day. It's not about who wins, who loses, but how can everyone's right be considered? How can everyone's need and the interest be factored in? And that, if you employ other alternative dispute resolution mechanisms, then becomes much easier to do that.
You are a mediator.
Yes, sir.
When it comes to matters of land, should we concentrate more on mediation, reconciliation building processes, as opposed to putting more focus on litigation?
Well, mediation is an alternative dispute resolution, very much encouraged by the court recently. The purpose of mediation is to have the parties themselves come up with solutions to their own problems. So a perfect example would be the 1984 East African Mediation Agreement. This was entered into after the collapse of the former East African community. However, despite the mediation, much of what was captured in the mediation agreement by a guy called Dr. Victor Umbrich, it was between the three heads of states, that's Kenya, Uganda, and Tanzania. Most of what was agreed on was never followed. And then again, where does it acquire the force of the law? Where is it taken to? Which court will adopt it as an order of the court or what was agreed upon? So that is why we are seeing so many people are still suffering, claiming pensions. And the purpose of that mediation agreement was to divide the assets of the member states of the community upon the collapse. So each country kept what they had to keep. But some of the countries, after the allocation, did not give it to the vulnerable people or the owners of the contributions for pensions.
Yeah.
So these are some of the challenges that we may have with mediation. Well, we may agree, but at what point will it acquire the force of the law and become an order of the court, and you can execute against it, on it?
Would it 100%, would mediation 100% solve land dispute?
As long as there's agreement. I mean, if Kakuzi would agree with the community, we are going to give you this, and they are not objecting to it, why not? Yeah.
And Kimathi, from this, there are expectations, especially they rise immediately after maybe a favorable court decision, but then again, implementation can take time, because sometimes there are appeals, there are surveys, and administrative processes. When it comes to managing expectations, how can communities manage expectations while these legal administrative processes continue?
What I would say is, at times those processes can take long.
Yeah.
And if you adopt a victim-centered approach to dealing with the issue, then you have to look at their rights once they're violated, and the longer it takes, the more it becomes difficult to address it. Now, if you listen to the issues that they're going through, there's so many issues that are affected. Rights here. There is even public utilities, things like hospitals and schools that they actually need titles for them to continue offering the service, and then there's the issue of the access. So we're talking of, for example, the right to education. Now, for a child who, grows up there and is not able to enjoy the right to education, and they miss that opportunity, it becomes difficult later on to say we're going to compensate you because they have missed a particular phase of their life. Same as the right to health. So people are not able to access their health. So somebody has died because they couldn't access the medical attention. So there's so many issues that are involved, which now, if you look at it, you cannot just say we're going to just wait until it happens. You have to adopt a victim-centered approach to dealing with it, so that this fast-tracked and ensure that the people get justice as soon as it can be done, because the longer it stays, the more difficult it becomes to remedy some of those violations.
Justice delayed.
Yes.
And Wakili, you know, a recurring concern is whether reopening these historical land claims could create uncertainty, especially when you look at Kenya's land registration system. From where you stand, how can the law correct historical injustices while preserving public confidence in the title deeds and also the broader land registration system? Now,
in establishing the National Land Commission under Article 67, what the Constitution of Kenya 2010 contemplated was resolving all these issues at once. And that is why there's a lot of outcry and criticism as we speak, that despite this ruling giving some reprieve, despite the National Land Commission giving some restitution in terms of 3,200 acres, it does not address entirely the issue of these leases.
Yes.
It has not said whether they expired or not. It basically kept off that. So they have not yet been entirely solved. Again, the National Land Commission can, under its mandate to investigate, do this after a complaint has been made by an individual or on its own motion. So basically the National Land Commission can investigate a title on its own motion. We call it suo motu in law. So if we have confidence in the institutions, then things should definitely work. Yeah. So it's not about a matter of public confidence or what, it's about the constitutional institution established. Yes.
And Kimathi, sometimes some land earmarked for historical restitution may be required for, say, public utilities like schools, hospitals, roads, and other important public infrastructure. How should the government balance the right to historical justice with the broader public interest, where land is needed for essential public service?
So as I mentioned earlier, if you follow the due process makes room for the things to be considered.
Yes.
So things like public participation, then that gives room for everyone to be heard. So when now that is done, then you're able to make a balanced decision in view of everyone's interest. So problem comes when such processes are not followed, the procedures are not followed, and therefore later on, other interests emerge that were not considered. But if you follow, the key is in following the due process, you know, in terms of whether you want to convert a particular part, you know, land for public use or, you know, for commercial use, etc., etc. The due process is always key.
Yes, the due process. And from where you stand, Ithadi, what reforms would strengthen both land registration and historical justice?
Well, some of the reforms that ought to be done to the prevailing regime on land registration is basically a roadmap on what matters should this constitutional commission that has been established mostly dwell into. What nature of complaints, they should be more specific on that. When you talk about historical injustices, what aspects or areas are we really looking at? Are we also going to consider how these lands were acquired, not only the leases that were issued? Maybe people bought land that for willing buyer, willing seller, on a willing buyer, willing seller basis. So some of these things should be a bit specific and more strict legally, so that we have a clear roadmap on how these matters should be handled. Because it's not the old Kakuzi issue alone. There are other people with very many historical injustices pertaining to land, even between private citizens, not only public land, yes, or community land.
And Kimathi, you know, at the international level, you know, in countries like Canada, South Africa, New Zealand, they have pursued restitution and negotiated settlements. From where you stand, which international lessons should we as a country adapt to ensure that when you are dealing with these land matters, especially when it comes to historical justice, every party feels well served?
The different actors have to play their role. Every actor here, starting with the state, which is the primary duty bearer here, they have a duty to facilitate the enjoyment of certain rights.
Yes.
So which means when it comes to ensuring justice is served, then they have to fast track it just to ensure that the communities get that. Now, on the other hand, the businesses, the enterprise, have got responsibilities. In this case, we're talking about the business enterprises. They have to comply these principles that have been put forward, that you have to look at so that you make sure that you've considered all factors that need to be considered, then you don't find yourself in the wrong side of the law later on, years to come. They call them the UN Guiding Principles on Business and Human Rights. So whereby you have to, look at, do your due diligence, find out, once you do that particular business that you want to do there, what's the impact on the society? And then for the communities that are involved, for instance, when they organize in associations, then they are able to advocate for their rights together because, if you're individual, majority of them are, from marginalized communities, so they're vulnerable. So, but when they organize themselves, as, in groups, then they are able to advocate and also participate in such processes effectively. Now, if you put all those measures together, then you find those are the good practices of how to ensure that such issues do not recur. Because if the state plays its role, the business does its role, the communities also are active and proactive in terms of agitating for their rights, then you find these minimal chances of the rights being violated, and where there is, then there is restitution for the same.
Very much indeed. Let me take your closing remarks, and I'll start with you, Wakili.
Well, very well. So, historically, very many things have happened, especially directed or perpetrated by the colonialists. We found ourselves there. She informed me before the show that she was born in Kakuzi, so she knows no other home. That is all she knows. And it's the right time now. We have to deal with all these things. So the ball is in the National Land Commission's court. They have to restore public confidence in them. They have to investigate these injustices keenly, without fear and without favor. It doesn't matter who it is. Let's restore public dignity.
Okay. Ujumbe wako wa mwisho.
Mimi ile naweza kusema, nasema tu serikali watuletee title deed, sababu shamba wameturudishia eka 3,200.
Yes.
Kwa hivyo tu wakubali tu, sababu tunawaomba.
Sawa. Kimathi, in less than 30 seconds.
So what I would say in view of that matter is that a sustainable agriculture sector cannot be built on unresolved historical injustices. And true corporate responsibility is based on adhering to government administrative actions to remedy. You also have to drop retaliatory actions, but then most importantly, you have to acknowledge the right to ancestral land as a fundamental right.
As a fundamental right. Thank you so much. That is Kimathi Kithure, who is a human rights defender, Rebecca Wanjiku, who is a claimant of land in Kakuzi, and Turunga Ithadi, who is an advocate and mediator when it comes to matters of land. This is where this conversation ends. Thank you for tuning in. My name is Migwi. Vivian Degwa is up next with Health Tuesday. Stay with us.